My name is Katie Egan, and I'm a member of Foley and Lardner's litigation marketing team. On behalf of Foley, we would like to thank you for participating in our 6th annual Staying Competitive and Compliant in the EU web conference. At this time, all participants are enabled in listen-only mode. Being recorded, the presentation portion will last approximately 60 minutes. You may print a copy of today's presentation by downloading the slides from the Files section found on the right side of your screen. Please note that in order to receive Staley credit, you must be logged in to both the web conference and participating on the phone. A very important note for New York and New Jersey participants, you are required to complete the attorney affirmation form, which can also be found in the Files section of your screen. I will announce a 5-digit code at a point during on your screen. I would like to introduce the hosts for today's web conference. Howard Fogt is a partner in the Washington, D.C. and Brussels office, and Sophie Lignier is a senior counsel in the, of counsel in the Brussels office. Howard, you may now begin.
Competition matters in the European Union. The first 5 presentations have focused on a number of important and continuing topics, including the evolution of EU and member state merger control policies, procedures, and remedies, general overall competition law and procedures as it relates to single firm and multi-firm conduct, including vertical restraints, developments in EU competition law, including privileged private restraints, class actions, and best practices for compliance. As is indicated, and as Katie indicated, you can get a copy of this material both on this webcast as well as eventually on the Foley website, both in terms of the printed and the audio content. This year we're going to be talking about a number of both new and recurring issues about which you may have questions that you wish to pursue during this conference or afterwards. But the first and perhaps the most basic issue is relative to EU competition compliance rules. Why do they matter? We're going to talk about distribution across the board in terms of new developments in this important area of vertical restraints. As has been almost always the case, we're going to talk about cartel enforcement and why it's important for U.S. business year or so, and we're going to discuss those as well. An important and increasingly important issue relates to horizontal cooperation and collaboration between competitors. And as always, there is an important interplay, and sometimes it seems conflict between intellectual property and competition law policy. We're going to talk about the evolution of EU damage actions and leniency procedures at the European and the member state levels, where there have been some important updates. transparency and understanding of compliance requirements. Just a few basic rules and procedures from past conferences. It is important that you understand and put into context the history and evolution of the European Union from a continent that has been long for centuries divided by culture, linguistic, social divisions, rivalry, and war. As a vehicle to resolve these past conflicts and to create, through a common market, a better life for all of its citizens and people doing business in the European Union. Essential to the achievement of that goal is the elimination of intra-European customs duties, quantitative restrictions, and imposition of a common policy toward third countries. Finally, as you, I'm sure, well know, it's been essential that there be a strong and workable system of competition principles growth of the European Union from its start in 1951 to the last accessions of countries in 2007. There are now over 25 member states of the European Union, stretching from Ireland in the west to Poland, Czechoslovakia, the Czech Republic, the Slovak Republic, Romania, Bulgaria, to the Baltic states. And so it's a very, very diverse but increasingly harmonized group of countries that are focused on achieving the EU remains the largest trading partner of the United States. It's the largest outbound destination for U.S. investment, and it's a market with over 400 million consumers. The economic prosperity of the European Union is driven by competition principles, which we're going to spend a fair amount of time talking about. As it's always that will be useful to you as you seek to guide your clients or seek to guide your own personal business action in doing business with the with people in the European Union. You can access these basic materials at the websites that are identified in the slide that's currently on the screen. And you will see when you do so that there are provisions prohibiting undue horizontal and vertical restraints, abuse of dominant positions, state states in regulating competitive behavior, as well as provisions that control and are expanding the free movement of goods, people, services, and capital in a single internal market. There are many, many sources of legislation in the European Union, and in the websites that are referenced, you will be able to see not only regulations which are binding on the member states, but also directives which that assist the Commission, the national competition authorities in the 27 member states, and the courts in each of those jurisdictions. So, why do European competition compliance rules matter? What is compliance? Why comply? What are the risks and rewards of compliance or non-compliance? Why does EU competition law compliance matter to a U.S. company? Are there differences in what is compliance? Compliance means observing the law. In business, it means proactively observing competition rules. Why comply? You can take it from me that competition is good for business, particularly in the EU, one of the largest economic markets in the world. What are the risks and rewards of compliance or non-compliance? As will be explained in this presentation, the risks of non-compliance can be astronomical, both in terms of fines and damages, as well as loss of Are there differences in legal standards between the United States and the EU that merit attention? Let me emphasize that one size does not fit all. There are important differences between EU and US law and procedure, and an effective policy must take these nuances into account. Having said that, I'm going to turn the program over to my colleague in Brussels, Sophie Lignier, who's going to talk about EU distribution. Sophie?
Thank you, Howard. So let's start with the current vertical restraint legislation. Vertical agreements, including distribution agreements, and as a result of which the prohibition of Article 101 of the treaty is inapplicable to vertical agreements which meet certain requirements. So these rules came into force in June 1st, 2010, and they offered an opportunity for the Commission to provide some clarifications on a certain number of issues. The first one that I would like to mention is with respect to given that these restraints are in apparent contradiction with the EU's goal to achieve an EU single integrated market. The new rules extend therefore the scope of the block exemption regulation to cover a greater number of situations. And to summarize, as a general rule, the suppliers may opt to restrict active sales by distributors to a specific territory or customer group. By active sales, let us remind you that it covers situations where the seller takes steps to attract the customers. Such steps, but where the purchaser has found the sellers and requires the products. So while as a general rule suppliers can restrict active sales, absolute restrictions that prohibit passive sales are generally not allowed under EU law. Next issue also clarified is by these new rules is that with respect to sales on the internet, it is viewed as a form of passive sales, and the restrictions on online sales are likely to be considered illegal. There was in that respect a ruling concerning a selective distribution system, the PFAB ruling, where the court recalled that any absolute ban on internet sales is a restriction by object, unless the ban can be objectively justified. There are also other examples of serious restrictions of passive selling that are identified in the guidelines, and they include a requirement that the distributor pay a higher price for goods which are intended for resale online than those made online. Any requirement to redirect a customer to another distributor's or manufacturer's website, where the website in question is located in a different territory to the customer, and also cover the situation where there is a requirement to terminate the customer's order once the credit card details reveal an address which is outside the distributor's home territory. So while, as we see, there are many restrictions on the use of the internet that will be seen as serious restrictions, the new guidelines nevertheless allow suppliers to regulate active online sales, and in that regard they provide some are allowed to refuse to supply pure online players. They may also impose quality and service conditions, provided that these are equivalent to the conditions applicable to offline sales. They also may require that a certain amount of the products be sold offline and agree on a fee with the distributor to support the latest online and offline efforts. Respect to resale price maintenance, which can be defined as the establishment of a fixed minimum or maximum price level to be observed by the distributor. So the EU takes, the Commission takes in that respect the position that fixed and minimum RPM are regarded as are being anti-competitive. No matter how small the market share affected by the restraints may be, so even in the absence of market power collusion, RPM will not be exempted. And there has been many examples where the Commission has condemned resale price maintenance. Also, nevertheless, the guidelines for the first time also, recognize that there are poor competitive justifications for RPM, and this follows in the Legging ruling in the US, where the US Supreme Court ruled that efficiency defense that is that can be argued, and the EU guidelines provide some examples where resale price maintenance can lead to efficiencies. These could be the case, for instance, when there is the launch of a new product or need to support short-term low-price advertisement campaigns. So in theory, there is an efficiency defense for resale price maintenance, according to which the practices concerned will fall outside of the prohibition criteria. However, in practice, it remains to be seen whether such defenses will be successful. Illegality for resale price maintenance. Again, an exemption under 1013 is always possible, but is subject to a solid justification. I would like also to add a few words on maximum and recommended resale price. The practice of recommending a resale price to a reseller or requiring the reseller to respect a maximum resale price do not generally raise competition problems, and the Commission permits such practices as long as they do not result in any direct pressure to fix prices. issuing such recommendations that they are not allowed to enforce them and penalize their distributors who choose not to follow these recommendations. Finally, with respect to minimum advertised pricing, these are policies prohibiting resellers from advertising a manufacturer's products below a certain minimum price. These policies are intended to control the price at which products can be advertised, but not the final price at which the products may be sold. And in the EU, such policies are considered as indirect resale price management. And they may be exempted only if the parties provide a solid justification for their MEP restriction. Let's turn now to the chapter on cartels and to go over the key developments for the last year. I'd like to start with a few statistics. As you see on this slide, the total amount of fine imposed by the European Commission amounted to 1.2 billion. That was the result of a total of 5 decisions taken by the European Commission. Mitsubishi and Toshiba. And the number of undertakings that were covered by these decisions were about 40, and the highest company fine has been imposed on Mitsubishi. They got a total fine of 75 million. What can we say in summary? There are not so many cartel decisions over the last year. However, there are some interesting points that I would like to point out is like and it comes out as being like seems to be a positive experience, and in particular as the procedure took no more than 10 months from the approach of the companies to the decision. Also an interesting decision in the window mounting cartel is that the Commission on an exceptional basis decided to reduce the amount of the fine of the companies, because in that particular case all defendants were monoproduct companies. Issue as to parental liability, there is really no change in that respect, and we see in the next slides what the additional clarification brought in that respect. And as to the inability to pay application, they continue to be successful. To just give an example, over the past 2 years and a half, there were about 40 applications, and about 15 have been successful. That were pointed out by the courts. I'd like to draw your attention to the issue of access to file under the EU transparency regulation. There were 2 interesting rulings in that respect. The question was raised in a case where the parties asked for full access to the statement of contents of a case file, and the Commission argued that the disclosure would undermine its leniency program because the companies cooperating will be more likely be sued for damages. This is not a commercial interest deserving protection. So according to the General Court, annulled the Commission decision denying access to the list. And the court went on to explain that exception to disclosures shall be strictly considered. So the court invites the Commission to make each time a concrete and individual examination of the content of the documents to see which ones should be disclosed or not. The court went on to say that the Commission cannot take a general and abstract position. Commission's internal documents have to be looked at as well in terms of access. And the court also emphasized that there was no presumption that disclosure would undermine public enforcement against cartels, and stated there was no exception for competition law in the Transparency Directive. So I will see later on as under the merger chapter, it's a controversial ruling that is likely to be appealed. And because in another ruling, the court decided for merger proceedings that there was a general Now turning to parental liability, the AXA ruling still stands. The general rule is that the parent company is liable for antitrust violations of its subsidiaries, but this is a rebuttable presumption, and therefore there is the possibility for the parent to provide evidence that the subsidiary acted independently. There was a case where the presumption, the presumption applied despite the subsidiary had two parent companies, but the Commission said as evidence indicated that they were in a position similar to that of a the decision, there was a parent's delegation of the supervisory powers to a subsidiary to supervise another subsidiary, and again the court said that does not affect the presumption. Also, the court confirmed that parental liability for a joint venture is established when it is demonstrated that examples giving some ideas of what would be considered as such an influence, such as appointment of directors, business plans, and so on. But again, this is a rebuttable presumption, which means that the relevant arguments raised to rebut the presumption have to be reviewed carefully by the Commission, and any reference by the Commission to a general statement or parental liability to rebut the presumption would be insufficient. So the Commission has to motivate carefully there was in particular a very interesting ruling known as the KWS ruling, which provided a certain number of clarifications as to the procedure in terms of Commission investigation. That I would summarize as follows: is one of the questions was, can a company call a lawyer and ask him to come as soon condition of legality of an inspection? Also, there was a question as to whether a company can ask the Commission to wait in the case 47 minutes for its lawyer to arrive before giving access to the premises, and the answer is no. The court found that the Commission had not infringed the rights of defense in refusing to wait for the lawyers. The time that the Commission has to give the company to contact its lawyers before it starts reviewing the documents depends on the specific company deny access to an office. not relevant to the investigation? And the answer is no. The court emphasized that the Commission has the right to go into all premises. The Commission treated this as an aggravating circumstance to the main infringement, justifying a fine of 1.7 million. In that respect, the court confirmed the Commission decision, considering the fine non-disproportionate to the infringement. And also the last point is that for those who are responsible for the inspection, also subject to an inspection decision. I will turn it over now to my colleague Howard for the next chapter on horizontal cooperation.
Sophie, thank you very much. As you have heard from Sophie and seen in the slides, there have been tremendous amounts of developments that have been generated by decisions of the European Commission and the European courts in terms of litigation. But as I indicated at the outset, there are many other sources of information again to emphasize that there are often significant differences between U.S. and European Union competition laws and procedures and indeed perceptions. Sophie talked about cartel enforcement and the rights of the Commission and the member state enforcement authorities to enter premises and interview people and take documents. And from a U.S. perspective, you need to keep in mind some of the very fundamental in a way that is significantly more restrictive the authority of U.S. officials to come and search premises. As is the case with a search warrant, for example, there must be a probable cause for the search of the facility, and that probable cause must be determined not on the basis of an enforcement official's view, but rather in the view of some non-litigation materials that may well be very helpful to you in counseling your clients as they conduct their business. In 2011, at the end of 2011, the Commission issued guidelines on horizontal cooperation agreements. Keep in mind that these are guidelines. They're not block exemptions. They're not hard and fast rules, but they are guidelines that are designed to provide parties with information about the likely enforcement intentions of national competition authorities in the member states. And they do as well have an effect, albeit not an automatic effect, on how the substantive laws of the European Union's competition principles are interpreted. So in several prior webinars, we've talked about important issues regarding exchanges of information among competitors. This can be very, very important in terms of membership sharing procedures that would be relevant. There is as well tremendous interest in and increasing guidance on how standard setting which can be very important in creating new and expanding markets, should be handled in the course of collaborations between competitors. There's guidance on R&D agreements. All of these materials can today on joint purchasing agreements. And while, as I said at the outset, there are very strict rules related to horizontal discussions of pricing and market allocation, coordination of production, a properly structured and safeguarded set of discussions on joint purchasing among competitors can, under many circumstances, be permissibly undertaken and can assist the companies involved. Arrangements do not raise antitrust concerns unless the volume of purchases permits the participants to effectively exercise market power, and that the volume being purchased jointly is not so large as to permit the participants to facilitate price fixing or otherwise reduce competition. The be defined pursuant to guidelines that the Commission has articulated in terms of a notice for purposes of market definition. There were safe harbors created, and the previous slide indicated what they were, both in the upstream and downstream market. But the rules make clear that even if the companies do not satisfy the safe harbor requirements, there are still opportunities to mitigate the competitive concerns and to not run afoul of Article 101. Operational procedures that can be very helpful in terms of ensuring the likely enforceability of a joint purchasing arrangement if it is to be undertaken. And I won't go through all of them, but what I will emphasize is that it is important to make a record of compliance, both in terms of the initial discussions that are had with respect to the establishment of the joint purchasing agreement, encourage you to have those meetings monitored by experienced antitrust counsel. There are a number of new developments in the merger area, and I'm going to turn the program back over to Sophie Lignier. Thank you.
Thank you, Howard. Yes, it has been, the 2012 has been a busy year for the Commission in terms of merger control. There has been developments, and to start with, I'd like to draw your attention to the adoption of the best practices on cooperation between the EU national competition authorities in merger review. This covers the situation where mergers do not fall under the EU merger control and are therefore reviewed by a great number of national competition authorities. So those are situations that raise problems and of legal uncertainty and delay and cost for companies. guidance on how these national authorities should cooperate, and they are intended, of course, stimulating the cooperation and the sharing of information between these authorities. Another important issue is the access to documents in the context of EU merger proceedings. As mentioned earlier under the cartel chapter, I mentioned this decision with a and the court in a recent ruling recognized a general presumption that documents are protected from disclosure in merger proceedings. So this is, as the opposite as what was decided for cartel cases, and here that applies not only to ongoing merger investigation, but as well as to closed investigations. So therefore, it would be very hard for parties to access documents submitted by the Commission and by other parties in the context of a merger review. Another interesting issue is the the Commission says in that respect that the first transaction that is notified has priority, and therefore applying this rule as the first notified transaction, which was here Seagate and Samsung merger, which was notified 1 day earlier than the second one, Western Digital Hitachi, was cleared without condition, and it was viewed in the context of the 4-2-3 merger, while the second transaction was viewed as a 3-2 merger, and therefore was cleared subject to conditions. So the Commission took the view that transaction. Also, I would like now to say a few words about the cooperation between the EU and US authorities in the context of merger review. By taking two examples of mergers that were reviewed last year, so by both the EU and the US, and involved extensive cooperation efforts between the authorities, but showing that despite this cooperation, it doesn't mean that there will the EU. The Commission took the view that the transaction will result in a near monopoly on EU financial derivatives traded on exchanges. But the same transaction was cleared in the US that took the opposite view, that the merger was not likely to reduce competition substantially. And the other case, the UTC Goodrich, is here a successful example of the EU and US cooperation. That was a large merger of about 18 billion acquisition, the largest in the history. And it took no more than 10 months after the signature of the deal. So here, that was an example of coordinated investigation that really resulted in similar conclusions. Now to say a few, to go over some few policy considerations that were discussed by the Commission late last year. The Commission is considering to simplify the merger procedures, but that it means to consider possible extension of the scope of the simplified procedure to include, for enormous set of information to be provided, and they would like to make the exercise less burdensome on some deals. So there is a public consultation that is expected maybe within the next weeks, at least early this year, should come out. There is also under consideration a reform of the merger control regulation itself, and that some points were unveiled by the Commission recently, and they mentioned that they are thinking of a possible review of the referral procedure between the Commission and the Member States. The consideration again a very time-consuming exercise. The EU also, further to the Ryanair Aer Lingus merger, is assessing the issue of non-controlling minority shareholdings. As you know, under the EU merger control, the Commission can review acquisitions of minority shareholdings as long as they confer control, but it has no jurisdictions to review the acquisitions of minority stakes without control. Another issue that is under consideration is the there is the example of full function joint ventures that may have no effect in the EEA and may still subject to the review because the undertaking concerned so are those that control the GV, and if the EU thresholds are met on the basis of the parent's turnover, then they have to file in the EU. Another consideration is given to the type of control that the Commission should give over mergers, and meaning mandatory notification as opposed to voluntary notification with possible considering.
Excuse me, Sophie, if I can take just a second to give the code for New York and New Jersey participants. Anyone seeking CLE credit in New York and New Jersey, your code is JAUSM. That's J as in jungle, A as in apple, U as in umbrella, S as in Sally, and M as in Mary. Thanks, Sophie. Back to you.
Thank you, Kathy. Now turning to the next section on interplay between intellectual property and competition law. There has been over the past years an increasing focus of the European the pharma sector inquiry over the past years. And in that respect, the European Competition Commissioner said in a speech that the strategic use of IPRs is now a Commission priority. So before looking at the most recent developments, let's go over some general principles. As stated in the EU law, there is no inherent conflict between IP and competition law. They are both necessary to promote innovation, and they share the same objective of promoting consumer welfare. However, there is no antitrust immunity intellectual property right is not in itself an abuse unless there are exceptional circumstances, and that was first mentioned in the McGill ruling back in 1991, and as further confirmed and clarified in the IMS ruling. Basically, the exceptional circumstances exist if there are 4 conditions that are met, and this refers to the IMS ruling. And these conditions are indispensability of IP, elimination of all competition, if there is no objective justification, and if there is prevention of emergence of new products. So once the exceptional circumstances are established, the IP to license. Also in practice, it remains unclear as to whether it would be what would be acceptable as objective justification. So this year it has been the Commission has given great interest in on the information communication and technology sector, dominated by regular court disputes about standards essential patents. There were, we can mention in particular, 3 formal investigations that were opened last year for alleged infringement of the FRAND commitments concerned the Apple and Microsoft complaints with the Commission concerning the licensing practices of Motorola Mobility and Google in the case of Microsoft complaints. So the Commission is examining whether seeking or enforcing injunctions on the basis of standards essential patents may potentially be abusive in light of FRAND commitments. And all these developments take place against the background of these of the Commission's approval of eye on the behavior of all market players in the sector. While it is recognized that in EU law that there are benefits of standard setting, it is clearly mentioned in the horizontal guidelines. Standards can also confer market power. Also, it is not a presumption under EU is understood not that it will not take issue with standard setting agreements as long as a certain number of requirements are met. And these are openness and transparency of the standard setting procedures, as long also as there is an unrestricted participation, meaning that it will be available to all who wish to work on the standard. Discriminatory terms, so the FRAND commitments. Outside of the safe harbor, it will be required to conduct an individual assessment, and but still many arrangements not covered by the safe harbor can be nonetheless justified as pro-competitive under EU law. I will now pass it on to
turn now to an important issue that remains a work in process or a work in progress. I'll leave it to you to decide what is the appropriate term, and that is the development of and implementation of as violative of the European Union's antitrust principles. Private enforcement in the EU has long roots, indeed private litigation in many member states dates back centuries, long before the European Union was created. Of competition policy, create legally enforceable rights to which national member courts must enforce. So EU rules on competition have direct effects The courts have long confirmed the importance of damage actions in protecting competition. And in the seminal Regulation 1, 2003, the Commission empowered national courts to apply directly the substantive and there are many, many problems that yet need to be overcome. There has been significant, if not essentially full harmonization of the substantive rules that are applicable across the 27 member states, so that price fixing is illegal in all of the 27 member states. Over the course of the last years in particular, public enforcement by national competition authorities has made great progress. As national rules of civil and procedural law apply to harmonizing the EU principles, continue to be disparate, and we'll be talking about that as we proceed through the remainder of these slides. Keep in mind that not only do you need to have a substantive legal right, but you have to have the ability to vindicate that right in a member state court in order to be awarded antitrust damages. Rules permitting to or limiting or prohibiting discovery, rules on the measure of damages, passing on of damages from one level of distribution to another, standards of proof that are applicable to proving your substantive rights, differences with respect to the presentation of evidence, including the right to and scope of witness examination, either before or at trial, and the limitation periods that are present that bar claims that are not asserted within the appropriate period. Fees. And as Sophie mentioned, there remain very serious issues with respect to access to EU Commission files, particularly relating to leniency materials, and one needs to be very careful if one goes down that leniency road to have one's eyes very much wide open in terms of the risks and benefits that might be involved. And indeed, as I said, there are many problems, and none fits this profile of public anti-cartel enforcement. On the one hand, public at the EU and national level have leniency programs which provide for enforcement incentives for the detection and prosecution of cartels. And on the other hand, at the national level, private enforcement promotes redress of injury caused by such cartel activity. So again, at the level of enforcement by the national so as to get leniency, but in so doing, they want to try to protect themselves from providing information to private parties that could be useful in private damage actions. As I say, in these leniency programs, all of the 26 states that have them require that a leniency applicant disclose in detail the illegal cartel activity in order to get the benefits of leniency. Readily assume that a natural place to turn would be to the European Commission or the national authority with a request for that authority to turn over or disclose the information provided by the applicant. As you can appreciate, there is a conflict. Such potential disclosure would be a significant disincentive to seek leniency in the first instance. In a seminal case decided in 2011, the European Court of Justice addressed this conundrum, but its ruling the European Court decided that it could not choose and would not choose between the conflicting public policy goals to enhance competition of leniency and private enforcement, and that it was for the national courts, all 27 of them, on the basis of their national laws to determine under what circumstances access to leniency materials should be granted. So it's going to be a function of national law and not EU level law that's going to determine whether access is granted or not. Competition Network, which urged in 2012 that such leniency materials remain confidential, but there can be no guarantee that that will be the case. We're going to conclude our presentation with important developments in the last year with respect to Commission policies and procedures that are intended to promote transparency. We started our presentation with a discussion of the question of compliance. Why does compliance matter? At the site indicated on the slide with respect to why compliance matters and what steps need to be taken to assure compliance. However, there are some significant differences between the benefits of compliance in the European Union and compliance in the United States. Those can best be described as the difference between a stick and a carrot. Under U.S. law, have or don't have effective compliance programs. In this slide, we set out the basic policy goal, which is that an effective compliance policy is long recognized as a best practice to promote conduct that is consistent with the antitrust laws. In the United States, under the sentencing guidelines, which is referenced in terms of the site, there is a strong benefit, a strong carrot benefits exist under EU law, and as I think Sophie indicated, indeed there's a strong negative bias against providing any benefit in terms of sentencing or fining from a compliance program. But there are as well other important differences. Many of them are a function of history and culture. that relate to whistleblowers and hotlines that pose important U.S. parenthetical that there currently is pending in the EU a reform of their data policy procedures that is creating significant dialogue between the United States and the European Union on this important issue of access to data. If you want to have further information about this issue, please reference my article, which you can find on the Foley website. Respect to procedures, and I'm not going to spend a great deal of time at this conference on the information that is available to you in this manual of procedures that's been published by the European Commission and can be found at the website indicated at the bottom of this slide. Suffice to say that if you're going to be involved in a proceeding before the European Commission, you should understand forth in the procedural manual that I would call to your attention. There are also important issues with respect to questions of confidentiality. We've talked about confidentiality during the course of this webinar and the issues that relate to it, and the Commission has provided some informal guidance on confidentiality claims that should be very, very much read with attentiveness. Keep in mind that one of the important elements relates to issues of leniency, and we've spoken briefly about that. But again, this guidance paper is available on the Commission's website since it was published in March of 2012. To summarize, there's no confidentiality claims in oral corporate statements in immunity or the leniency process. Think about what that means. In a competition context, evidence of an alleged infringement may be very difficult to determine in advance, and may as well involve some of the most highly confidential and proprietary information that a company might have. Obviously, no confidentiality for old information that is routinely not held to be commercially sensitive, and no confidentiality for employee names, which in the European Union, with its important privacy principles, is spoke about leniency, and I'm not going to take a great deal of time to discuss the issue here, but you can read the presentation and also look at the website and see what developments have occurred with respect to leniency and the revisions in the leniency program that have been published by the European Competition Network. Suffice to say that there have been three major and that there is now a standard template for those summary applications that can be used in all jurisdictions. They can be submitted in English, except for Cyprus, France, Hungary, Italy, and Spain, where it is a requirement that the application be submitted in the national language of the authority. And then finally, major issues. Employees and directors for interviews. We've talked about the issue of the confidentiality of the substance of the application, and that continuing policy problem may undermine the effectiveness of the leniency programs of the European Competition Network. That concludes our presentation of this sixth annual review of key developments on competition matters in the EU. We're going to turn the video portion of the presentation will be available on the Foley website, and the written presentation itself in PowerPoint form can be downloaded either online during this webinar or afterwards on the Foley website. Thank you very much for your attention.
And Camille, if you could open the phone line queue for questions and answers.
If you'd like to ask a question over the phone, please press *1 on your telephone keypad. If you're using a *1 if you'd like to ask a question. And it looks like we have no questions.
Okay, I am going to send our survey to each of you. If you could, please take a few minutes to fill out the survey and give us your feedback. We would really appreciate it. Thank you all for joining us for the 6th annual Staying Competitive and Compliant in the EU web conference. This